Okay, well, welcome to the Northwest Suburban Estate Planning Council's September webinar. This meeting has been approved for 1 hour of continuing education credit. If you'd like to receive CE credit but you didn't pre-register for it, please email Janine Darling at nwsepc@yahoo.com. Those are the initials of the Northwest Suburban Estate Planning Council. nwsepc@yahoo.com. She'll invoice you the $15 fee for members or $50 for non-members. And feel free to reach out to Janine if you have any questions. A brief survey of today's webinar will be sent next week, if not sooner. Please take a moment to give us your input by completing the survey. We value your feedback and recommendations for future topics. This is an organization for our members, so we want to make sure that we're providing everything that you guys and gals are looking for. Before we begin with today's presentation, I'd like to recognize our sponsor, Midland Trust Company. With us today are Maura Mannix and Cindy Tolan. Ladies.
Good morning, everyone. I'm Maura Mannix, if I've met you in the past, and introduce Cindy Tolan, and we are Midland Trust Company. We were formerly, if you know the background, we were ATG Trust Company for years, and Midland Trust Company bought the assets of ATG Trust Company as of June 1st this year. And we've had a fabulous transition. As you can see, we're in our new offices downtown. We moved across the street to 225 West Washington. With Midland now, it's really what we're saying. It's same people, new name. It brings us more enhanced operations. It brings us better technology. It brings us a bigger background because we are now owned by Midland States Bank. The transition has been wonderful. But we still do what you've known what we've done in the past, estate administration. The number one estate administration trust officer, Cindy Tolan. We do special needs trust, guardianships, ongoing trust. We can act as your corporate trustee. We're happy to talk to your clients anytime during the process, even if they're meeting with you and doing their estate planning and are even just kind of intrigued or want to understand how a corporate trustee works. Give us a call anytime. We're happy to have a Zoom call like this with your client. We can use Teams, we can use a conference call. We can meet with them if we're able to. And just to kind of explain to them what a corporate trustee is and how it works, it kind of takes the fear out of the puzzle as they're navigating this entire estate planning process.
I think we still do delegated and directed trusts. So I know a lot of the bigger corporate fiduciaries won't do delegated trusts because they want to bring all the assets in-house. So we will do delegated, especially if there's a LLC or a corporation or something family-owned that somebody has and they can manage it. We're willing to do those. So as Mara said, it's still the same group of people. We're just the Chicago presence for Midland States Bank and the trust department.
And to visit us, we are midlandtc.com because there is another Midland Trust Company in Chicago that does like self-directed IRAs and that's actually based out of South Dakota. That is not us. So midlandtc.com or visit us on LinkedIn, like our page. We're here anytime for you, and we're so looking forward now to Steve and Heather to talk to us this morning. Thanks, everybody.
Thank you, ladies. For today's presentation, we do have quite a bit of content here. And unfortunately, it looks like our comments are not active on my screen. So we ask that you do jot down any questions you have. We'll leave some time at the end to address any questions you might have. But today's presentation, Succession Planning, the Estate Plan for a Business, is going to be presented by Heather Walser and Stephen Magala. Heather is a shareholder with the Lavelle Law and has more than 18 years of experience working with individuals, small businesses, and Fortune 500 companies. Stephen also is a shareholder with Lavelle Law, and he specializes in and engages in mergers and acquisitions, banking, corporate real estate, and estate planning matters. Heather, the floor is yours.
Wonderful. Well, Keith, thank you so much. And thank you all for being here. As Keith said, we have a lot of material to cover today, but we did set aside, Steve and I set aside some time at the end for questions, and we're happy to address any questions that come up. We just ask that you wait until the question and answer period, and we'd love to take any questions at that time. So one of the important things to think about, especially in this group, because we are here from all different fields of advising our clients in these matters, is that successful succession planning really requires a team approach. And by that, I mean a team of advisors to work with the client for the best outcome overall. Because there are certain areas of expertise in which each of us practice really the best way for clients to address the succession of a business that they've worked hard to build is to have each advisor working in their particular area and giving their input so that collaboratively the client gets a better outcome. So just as an example, typically we want to have someone there, an M&A broker, valuation consultant, someone who can help advise the best way to maximize the value of the company. Oftentimes, clients of ours, Steve's and mine, they sort of view a sale transaction or a succession for their business as a retirement, where they think, well, once I'm 65, I can just hang it up and stop working. But that really does not achieve the right result in most cases. Ideally, the client should begin thinking about any sort of transition in advance, working with a broker, valuation consultant to maximize the potential value. So in addition, insurance and financial planning are often incredibly important pieces of the puzzle. For funding buy sells or just for making sure that the client has maximized value and planned for the rest of life post-business, post-involvement in the business. Certainly an accountant CPA needs to be involved to help build the structure that best minimizes tax impact or maximizes tax benefit. And then finally, this is where Steve and I come in, the attorneys who document any sale transaction or develop a scaffold or a structure for any estate planning that's required. So if we can move.
Sorry, you'll have it. Keith, can you advance the slides, please?
Yeah. And just a little bit about me. So I run our estate planning and estate administration group here at the firm. So really I'm immersed in all of those areas, but what's really nice about the structure that we have here is that Steve really has a lot of experience and expertise in papering the deal, planning for the merger, planning for a sale. So we can really work collaboratively along with the rest of the team to best structure the plan for the client. So one of the important pieces of it, certainly from my perspective, is ensuring that the client's estate plan implements whatever their wishes are for the business in the event of death or incapacity. And that's an important note. Often clients think about what's going to happen when I die. That frequently is front of mind for people. But what they fail to think about is what would happen to my family, my loved ones, or my business if I become incapacitated somehow. And that's another part of the picture when we implement a comprehensive estate plan. We want to cover both of those possibilities, particularly when there is an ongoing business involved. So really, when we do estate planning for business owners in particular, if you see here, there are really three big points of consideration to bear in mind as we structure their plan. And the first is ensuring that the client, first of all, has estate plan documents. It's amazing to see how many of our business owner clients just haven't gotten around to it, don't have their estate plan documents in place. So important to have those documents in place. And additionally, it's important to make sure that those estate plan documents work seamlessly with the business structure to implement the client's wishes at death. So that ties in with the second box there, which is the client's relationship with the business and the other owners. So if we've documented the business properly, there are going to be operating agreements, shareholder agreements, documents and structures in place that govern the relationships between the business owners and the various parties involved in the business. Now, what is crucial in this piece of making the estate plan work is ensuring that the client's wishes, if it's one owner of multiple, making sure the client's estate planning and succession wishes fit in with the plans of the other owners. So, one owner may think, well, I'm just gonna, leave the business to my kids. Well, the other, shareholders, owners, membership holders, they may not be okay with that. So certainly you can never do the estate plan documents in a vacuum. Everything has to be interrelated. And then finally, certainly in our practice, given the types of businesses that we represent, the succession plan frequently involves bringing children into the business or the next generation, which can be part of the lifetime succession plan, but also is very important to think about in terms of the estate plan. So the succession plan for one of the owner's interests if he or she dies and wants the children to be involved. So all of those pieces of the puzzle are really part of making a comprehensive, effective plan. So if we can advance the slide, we'll kind of touch on this. So in terms of just the scaffold or the structure of the documents, they're really kind of a basic toolkit that we use. And within that toolkit, there are a myriad of options in varying levels of complexity, depending on how much tax planning the client needs to do. But as a general rule, the basic straightforward documents, we always want to have a will in place, although in many, if not all cases of business owners, a will is not enough. A will does not protect you from probate court. It doesn't, keep you out of that long and painful process of probate. It's also very public. So while a will is frequently better than nothing, it's only slightly better than nothing. So really the ideal structure, among others, is to have a living trust in place. And that particularly in the context of a business, we really want to be sure that there is a trust structured to both avoid probate, which is important, but also to provide a mechanism for the ongoing management of the business interest without probate, but also with, putting the people in charge that you want in charge. And here's a case again, where it's very important that the estate plan or the trust matches up with the corporate structure in terms of rules about if the entity is structured as an S Corp versus, a C Corp or other types of structures. That affects the way that we have to set up the living trust, among other things. So if you have advisors working in silos where, one advisor does the estate plan, one is, prepping for succession via merger or sale, but they're not communicating with each other, the documents might not work together properly. So incredibly important to make those work. Finally, the last types of documents that we frequently use, and apologies, I guess evidently we're doing a fire alarm test in our office today. So we'll get a little extra interest here. In any event, as I mentioned before, preparing for if the client becomes incapacitated is paramount. It's just as important as being prepared for the client's death. So one of the other ways that we do that, in addition to a living trust, is powers of attorney for property, finance, and also powers of attorney for healthcare. So the really important factor with those is ensuring, again, that they seamlessly work with the structure that's in place for the business. If the business provides, the shareholder agreement, the operating agreement, if those documents provide a plan for the death or incapacity of, particularly the incapacity of a member or a shareholder, we want to be certain that the power of attorney documents mesh with those and implement the same strategy. So that's kind of the 30,000 foot view on why it's so important for a team of advisors to work together collectively to ensure that a succession plan or sale or any other sort of strategy for a business owner, it's implemented in the way that comprehensively achieves the client's goals. So that's kind of the big picture on estate planning and why it's so important that all of these pieces work together. And this is where I hand it over to my partner, Steve.
Again, sorry for the fire alarm test.
Yeah.
I don't know why they're doing it so early. All right, so I want to spend some time on just a few comments on the equity interest in general. Next slide. All right, so as many of us here know, when we're dealing with business owners, the equity interest is often the single largest asset of the estate. So it warrants spending time thinking about how to plan for it. So what we need to do here is make sure that we plan for it appropriately so we can maximize its value and then take care, obviously, of the owner's family that depends on the income from that equity interest. And as we also know, business owners can pass unexpectedly or become disabled, and so we want to make sure that we have a plan in place that will minimize the impact of that event on business and its stakeholders and the owner's family. Next slide. Okay, so here's some stats that we found with respect to the equity interest. About half of business owners or so, have a formal succession plan in place already, but less than half of the owners are concerned or not concerned about who's going to run the business in the event an owner dies, or becomes disabled. So we need to really kind of figure out, and there's a huge market out there, as you can see from these stats. There's a huge market with respect to these business owners and the need for succession planning, and what that really kind of means is like Heather talked about. We want to make sure that we have a estate plan that kind of meshes with the overall succession plan for the business, and really in large part that succession plan is going to be the governance documents of the organization, which would include the shareholder agreement or operating agreement, and in particular the buy-sell provisions in the shareholder operating agreement. Next slide. All right, so we mentioned shareholder and operating agreements, so I just want to kind of walk you through kind of our checklist of issues that we kind of think about when we meet with our business owners and discuss succession planning. And they kind of fall into these 5 categories here: management continuity, managing major events, transferability, non-compete, and then the ability to sell. Next slide. All right, so when we talk about management continuity, what we really want to do is kind of figure out who are going to be the ones that are going to control the entity, whether they're managers and members of an LLC or shareholders and directors of a corporation. We kind of really want to lock that down. We want to prevent any increases or decreases in those numbers, and we want to just make sure that we know going forward who's going to be in charge, and with the goal of ensuring a smooth transition and preventing disruption of operations with the entity going forward. Next slide. When we talk about managing major events, we around here we think about it as planning for the 4 Ds. So we have the death of the owner, potential disability of the owner, maybe a divorce, and departure, whether voluntary or involuntary. So when we draft these buy-sell provisions and the operating agreements and shareholder agreements, we really want to kind of keep these 4 events in mind and make sure we have a plan in place upon the occurrence of any of these 4 events. So next slide. Along with that is, is the issue of the transferability of the interest. So with respect to each of these 4 events, we want to think about, to what extent that interest is going to be transferable. And as many of you know, there's really kind of 2 basic approaches. Either the company can redeem the interest, or there could be a cross purchase by one or more of the owners. And this is really important decision because, who holds the option can really kind of have a big impact on how this is, what's going to happen with the business, and the interest that's affected. So we really need to resolve the conflict, right? When you think about it, say, let's have a hypothetical, 3 owners, 1/3 interest each, and one of the owners passes. So what's the most important thing probably to that family of the deceased owner? Well, they're probably mainly concerned about liquidity for that interest, right? They want to kind of take that interest. Generally, if kids aren't involved, they're going to want to kind of step away and just get liquidity for that interest. But, from the perspective of the company or the other 2 owners, maybe they're okay with having a minority interest owner who can't really, meaningfully impact the business operations. Maybe they're okay with them sticking around, and certainly any sort of buyback, could trigger a large drain on the company's cash. So, there could be an interest there, competing interest to not force the sale. So we really kind of need to balance that interest and have a good conversation with the owners as to how they see that playing out in terms of, is it going to be essentially a put option that the family's going to have to be able to put that equity interest either to the company or to the other owners, or is it going to be essentially a call option, which the remaining owners in the company will have, and they'll be able to exercise the call and at their option with respect to whether or not they want to buy that equity interest.
And Steve raised, I just want to jump in for a second. This is another place, coming back to our point earlier about the fact that we really want a team of advisors looking at all the different facets of this kind of transaction. From an estate planning perspective, it's incredibly important if there's any kind of tax that's going to have to be paid at the death of an owner. If there's no liquidity to pay it, that can be another huge problem. I mean, it's one thing if a trust beneficiary or a minority shareholder needs to be compensated, but the IRS doesn't really, they're not very flexible. So it can be a huge concern for the business if they have this large, one of the deceased owners has a large tax liability. And that is where, for us as professionals, insurance can play a huge role, huge. And we really like to work closely with the team of advisors to ensure we've covered that possibility.
Right, so that kind of goes along the lines of that 3rd bullet point there in the slide with respect to funding the buyout with life or disability insurance. The other issues I want to talk about with respect to transferability are, okay, so if the interest is going to be transferred to either the company or to the other owners, how are we going to value that interest? And the first 2 kind of sub bullets there are kind of typically what owners want. They want a fair value. They want it generally to apply to all the owners. And then so the issue then kind of becomes, okay, how do we get there, right? Is it going to be through an appraisal process? Is it going to be some sort of formula or an annual agreement? And I'll tell you, at least in my experience, the annual agreement is probably the least desirable because, I mean, I would almost equate it with funding a revocable trust, right? We can do the greatest documents, but if they don't follow through with the funding, it's kind of worthless, right? So kind of same thing with the annual agreement. Maybe they'll do it for the first year or 2, but then, eventually they'll just punt it or forget about it. And then again, that becomes worthless as well. So, I would definitely strongly urge owners to either come up with some sort of appraisal or formula for that valuation.
Where that especially becomes an issue is when you have a beneficiary who shows up with no involvement in the business, but mom or dad died, and they don't care about what the owners agreed to 20 years ago when they set up the business. They care about maximizing the value that they're going to take out of the business.
Right. Along with transferability, we often allow for certain permitted transfers for estate planning purposes. Again, putting that interest into the revocable living trust, like Heather alluded to. And oftentimes, the equity interest is valuable. There's a lot of value there, and the company or the owners may have difficulty, paying a lump sum cash payment. So, we often provide for payment terms that way of installment payments and interest rates. And so those are all things you have to think about is, okay, if it's going to be seller financing, then we have to think about, what those loan terms are going to be. And then final thing with respect to transferability is really kind of the ability to expel a shareholder member. Do we have the ability to kick somebody out? Especially, it's I think important with respect to any sort of licensed type business, right? So anything like doctors or dentists or whatever, anything where if they no longer have a license, then there should be some sort of mechanism to be able to kick them out and purchase their interest. Next slide. We talked about funding with disability insurance, and so when we do that, we want to make sure that the disability definition in the operating agreement kind of ties in with their insurance policies, so that there's no kind of issues there with respect to the definition of disability. And then overall, with respect to the agreement, we want to make sure that the agreement complies with Code Section 2703, which will then allow for the IRS to respect that agreement and not disregard it for purposes of estate tax. And those are the three requirements there, to enable your agreement to comply with 2703. Next slide. The next issue when we think about these shareholder and operating agreements is maybe putting some non-compete provisions in there. And it's a really good idea, I think, to do because it's not an employment agreement, so it's going to be a lot easier to enforce. The consideration is certainly more clear. And one thing I do want to point out with respect to at least employment agreements is Pritzker recently signed a new bill that's going to go into effect next year that affects non-competes for employees. So just as kind of an aside, I wanted to mention that to everybody. We do have details about that bill. It's on our website, lavellelaw.com, and it's a pretty recent article. You should be able to find it under our articles tab, but it kind of spells it out there. But so instead of worrying about complying with that in an employment agreement, if you're dealing with the owners, let's just put it in the operating agreement, shareholder agreement, and the courts are just more likely to enforce it. Next slide. Final issue here is ensuring the ability to sell. So this can be important if you're representing a majority shareholder or a minority owner. So if you're the majority shareholder, you maybe want to think about inserting in some drag along rights so that you can drag along those minority shareholders and ensure that you can sell the entire equity interest of the company. And kind of conversely, if you're a minority owner, maybe you want to think about putting in some tag along rights so that the majority owner sells and the minority owner can get out too, roughly on the same terms. And then the final bullet point here is with respect to mergers. The Business Corporation Act 11.20 says that you can vary the 2/3 voting requirement by way of amendment to the Articles of Incorporation. So you can just have the Articles of Incorporation provide for a different voting requirement. That can't be generally less than a majority approval. So you can then have those changes to the Articles of Incorporation for a corporation. And then as in the shareholder operating agreement, you can then specify that there aren't going to be any changes to the articles unless a majority of owners approve or 2/3 or whatever it is. So you kind of lock in what that voting requirement is going to be for a merger, which could be valuable. Think about it if you have a majority owner that you're representing, but he's maybe not necessarily 2/3. So this way, it kind of gives him the ability to ensure that a merger could take place. All right. So also, when we think about succession planning for our clients, we want to have at least a conversation with them about 5, 10, 15 years down the road, whatever. What's their exit strategy if they have one? no one's going to stay in the business forever. How do they plan on getting out, and if so, how? So we kind of have three basic strategies I kind of want to talk about. The sale to employees, a sale to a third party, generally a portfolio or strategic buyer. And then often overlooked one is a sale to an ESOP for a corporation. Next slide. So what are the advantages of a slow sale to employees? Well, there's some really good ones here. It avoids disruption with employees, suppliers, and other stakeholders because you're selling to somebody who's intimately involved in the business, who can kind of manage, who's probably managing those relationships already, really. It allows for the owner to have an installment sale. You can have a drip sale over time. It's good for tax purposes. You can kind of spread that tax bite out over time. And also, as part of that installment sale process, when you're selling little pieces of equity slowly to your employees, it allows the owner to maintain control of the process, to vet these future shareholders, make sure that they're ready for equity ownership, and then see how they do with a little piece of equity, and then maybe give them more if they're doing well. And it's also a really good way to preserve the owner's legacy, because the owner stays involved longer versus an immediate sale. There's a drip sale, so the owner is generally still involved, helping to run the business. Excellent. All right, so in this strategy, we're talking about a sale to a third party, generally a portfolio or strategic buyer, like a private equity firm or something. And with third parties, you really have to have clean books, right? So what we want to do is we want to get, if that's going to be a possibility, we want to get our clients thinking about cleaning up their books, 3 to 5 years out, because oftentimes, as you know, owners like to run personal expenses or whatever through the business, drive down that taxable income. But in this situation, we want to really not do that. We want to really increase EBITDA and get a good multiple. So we want to get the owners kind of thinking about doing that, at least a few years ahead of time. And when we have such a third-party sale, we want to make sure we get a broker or a rep involved who can really kind of drum up interest and really kind of shop the company around and create that auction strategy to increase the value. Oftentimes, especially this year, we're seeing it with respect to our deal flow, at least. The timing of the sale to coincide with a fiscal year end or calendar year end. We're seeing clients who are concerned about the income tax changes that might be coming down the pipe next year. So, trying to get stuff done this year is really important to them. And then from the potential buyer's perspective, especially if they don't have a management team in place already, so it's not like a bolt-on acquisition for them. And it's more of a portfolio acquisition. You're definitely more attractive to a buyer if you have a strong management team in place already. Excellent. All right, an often overlooked strategy is a sale to an ESOP with respect to a corporation. A little plug here for our firm. Over the past few years, we started an ESOP practice. We picked up former chair of Holland & Knight's ESOP practice to help us bring ESOPs to the middle market, and because of transaction costs, at least perceived transaction costs, a lot of middle market companies thought that they were kind of just locked out of this strategy, but we don't think that's the case. So let me back up, I guess, with an ESOP. What is an ESOP? It's really just a defined contribution employee benefit plan that invests in stock of the company. There's really good tax benefits here with respect to the selling shareholders. Oftentimes, the selling shareholders can defer or eliminate the capital gain on the sale. If the company is a S corporation and there's 100% sale to the ESOP, then basically the ESOP pays no income taxes on a share of the income because it's a flow through to the ESOP, but the ESOP itself is tax exempt. The company's contributions to the ESOP to fund the share purchases are also tax deductible. So it's a very good tax strategy with respect to a sale of a corporation.
Particularly now when the capital gain issue is sort of so in flux, this is really an important thing to think about, because the capital gain, given what's on the horizon here, we think it's going to be very important to mitigate that capital gain in the case of a sale.
And And the other non-tax benefits, you give employees an ownership interest in the company, helps motivate them, helps improve the culture. And it can be used in a variety of situations, as that last bullet indicates. Pretty much any situation where we have an owner who wants to retire and get out, but buy out an inactive owner, you have an estate sale or a divorce sale, or some key management or key employees want to buy out the interest. So these are all good situations where an ESOP can be considered. Next slide. Okay, so we kind of come up with some characteristics for what we think would make a good ESOP candidate. We kind of list them here. We really want to have a really strong management team. That's very important to the buyer, who's going to be the ESOP trustee. We want to have a solid performing company with stable cash flows. In terms of size of the transaction, we can get it done for employees that are only 10 employee size companies with a value of at least $2 million. So we think we can add a lot of value there and get those deals done. Whereas if you go with a larger firm, frankly, it's going to be priced out of the market. You're not going to be able to get that deal done. So we think we can offer a pretty good a good value proposition for these companies that are in the middle market that may be considering an ESOP. And if you have further questions on that, just we'll have our contact information at the end. We can put you in touch with our ESOP chair, David O'Leary. Next slide. So that's really it for us. We wanted to leave time certainly for questions. So in summary, kind of just summarizing everything we talked about. When you're talking about doing a succession plan, you want to get the team involved. The valuation guy, accountant, and financial planner, insurance guy. Get them all involved. Have a good conversation. You want to make sure you're working with the estate planning team and making sure the estate plan meshes well with the shareholder agreements and operating agreements. With respect to those shareholder agreements and operating agreements, we want to make sure that you're going through that checklist, satisfying those categories, and probably most importantly is planning for those 4 major events, the 4 Ds we talked about. Talk to the owners about a exit strategy. Think about maybe how they want to position the business and their own exits. And then with the ultimate goal here of just ensuring a smooth transition of ownership, preventing disruption of the operations of the company, and ultimately taking care of the owner's family going forward.
Yeah, I don't think we can stress enough how important it is to ensure that all the different areas are being advised on, and that no one's working in a vacuum in terms of, maximizing value, ensuring continuity of the business, implementing an estate plan. Everyone, providing insurance and liquidity for any deals or any deaths. It's so important for everyone to be working collaboratively and viewing the clients and the business's needs holistically. It can really be problematic when any of those pieces are done in a vacuum. We've sort of seen the downsides of that, and that can be anywhere from litigation with disgruntled beneficiaries, to problems with the ongoing continuity of the business, to unexpected death of a member or an owner that drastically affects the value of the company and the continuity for employees. So in terms of planning for the succession of a business, whether during life or at death, it's not first of all, it's not a one-size-fits-all proposition. And secondly, it's incredibly important to be sure that every facet is addressed.
Yeah, I mean, I think our firm certainly has seen an uptick in estate and trust litigation. There's just more at stake, right? These baby boomers are getting older, they have more wealth, and there's just more to fight about, really. So how having these documents in place will kind of go a long way towards minimizing that kind of conflict.
So we can certainly open the floor to any questions, and I guess we don't have the ability, it doesn't look like, to do that via chat. So please, if you'd like us to address anything, feel free to unmute and just shout out your question to us.
Or just discuss some of the issues you're having with state succession plan.
So I've got a question I'd like to see if maybe you guys can address. Got a situation where a business is worth, say, $9 million, and there's 3 equal partners. The buy-sell agreement says each one gets paid their share, or their heirs get paid their share of the business upon their passing. So as the concern is if after the first one passes, if the value of the business is worth $9 million, his estate would get $3 million. And then if the second one passes away, that $9 million is then split 50-50. So that second owner, when he passes, their estate gets $4.5 million. Is there any structures or anything you can recommend to kind of equalize those payouts over, if just so that there isn't a benefit for, the last one standing wins the most?
Probably the best way to handle that, I think, would be after that first passing, be a good time to kind of revisit that shareholder and operating agreement, those buy-sell provisions, and kind of see what makes the most sense going forward. The problem, of course, is that interest is worth more because that the value of that interest did go up proportionally according to the book value because of the prior buyout. So that's definitely a conversation I think you would need to have among the owners with respect to, okay, so maybe do we need to tweak the valuation that's in the buy-sell provisions, as a way to kind of dampen that effect.
Maybe do a wait and see buy-sell agreement where a portion gets paid out and it gets reevaluated with potentially a future additional amount to be.
Yeah, I was thinking like more along the lines of like maybe an amendment with kind of a tiered valuation structure where if there's another passing within the first X years, the valuation is a little bit lower, but going forward, then that kind of discount diminishes or something to think about. So, but it's always a good time after any sort of these major events to kind of sit down and just did that go well? Did that transition go well? Is there anything we need to tweak going forward? And then that's a good scenario to think about.
I have a question about a slow sale to an employee over time. And the question is regarding, we're thinking about death and disability of not only the owner, but of the buyer of the business. And the employee buyer of the business, the conversation has now gone to who owns the life insurance on the buyer of the business. And we want the beneficiary to be the business itself, the business owner, current. What are the thoughts surrounding that ownership of that policy?
Yeah, I think generally you want to peg the beneficiary certainly to who's going to be buying the interest, and so oftentimes it's the company is going to be the beneficiary if they're going to be redeeming it. And oftentimes, we also see the company as being the owner of the policy, sort of often the ones that are funding those premium payments. So, but if it's going to be more of along the lines of a cross sell, then you typically want to have each owner purchasing policies on the other owner, which can be kind of one of the disadvantages of cross sell is that can get expensive with all these multiple policies. So it's that kind of would argue for just having kind of the company be the one redeeming the interest.
Thank you.
Any issues you guys are facing within your situations, or any war stories or anything you guys want to talk about?
Going once.
I'll just say with respect to valuations, are you guys finding that generally you see formulas more so than the annual agreements or and appraisals, or what do you guys typically see, or what do you guys recommend?
This is a group discussion. Feel free to join.
And kind of as an aside too, to address Keith's question, although it's not always ideal, sometimes that is the way that we address that issue, which is setting kind of a strategy for determining valuation in advance, as opposed to just a straight fair market value to kind of equalize among the different potential estates or beneficiaries or whoever is going to ultimately be taking. It's not perfect, but it's kind of it's better than just allowing the result that you were talking about, Keith.
Yeah, I think also, if you keep in mind that those surviving owners will have the most future involvement and impact and investment in the business, there is, a case that can be made that they should have a higher ownership interest in that going forward. It's just unfortunate for, if there is, close deaths that one, because of dumb luck or timing, one estate gets more than the other. Do you see a difference in valuation discounts depending on which type of potential succession plan they have chosen of those three?
Not really. If it's going to be a buyout by the other owners or the company, I think the valuation discounts are going to be there regardless, and the percentages can vary depending on the nature of the interest and how much control it has and all that. So I guess that would be the answer. What are you guys seeing with respect to your clients' exit strategies? Are they tending to more sell to key employees, or bring family members in, or looking for a third-party buyout? What have you seen in the market lately?
Often for us, for what it's worth, it's difficult, I find anyway, to get these business owner clients to focus on this issue. It's kind of, they're busy running their business and they're doing what they're good at. And even if we're able to get them in the door to just talk about, let's at least paper up your estate plan so it's not a catastrophe if something unexpected happens, it can be challenging to explain. Like I was saying before, we have to overcome that assumption sort of that, well, I'm just going to work really hard and then eventually I'll be able to just retire or sell without any strategic planning in advance. So that I find at least that to be sometimes difficult to get these owners to focus on that. And kind of, not to keep coming back to your scenario, Keith, but I guess that's almost the flip side of the scenario we were talking about, is in some instances, the unexpected death or disability of one member or shareholder, it actually, depending on the size of the business, I've seen where it actually so negatively impacts the value of the business sufficiently that the two remaining owners in your situation actually end up worse off. Mm-hmm. So it kind of can go either way. It really just depends on if they have developed a good exit strategy and a good plan for continuity so that an unexpected death or disability doesn't leave them in a lurch for, continuing to run the business.
Yeah, and especially if they're looking for an exit by way of a third-party sale. I mean, it's very important to try to, start thinking about doing that a couple of years out, like I mentioned during the presentation. Cleaning up the books and just trying to, maximize EBITDA and get a really good multiple.
Stephen, Heather, I have a question. I'm coming in late with a client on they've not been my client for a number of years, but apparently what's happened is there's been a cross purchase arrangement that's been in existence for years, and they've been layering new policies on policies as the value has increased in the business. But now apparently one of the partners is uninsurable. So is there any remedy for this group other than to convert the plan to a redemption agreement? Because apparently they can't get the insurance for the other partner. And I don't know about self-funding. I'm unaware as to whether that could be done. So what have you guys seen in terms of that? Are you kind of forced to go to the redemption agreement?
Yeah, I mean, have that conversation with the owners if they're really still insisting on a cross purchase by the other owners. Do they have the resources to make up that gap between the insurance and the purchase price? And if not, you're almost, I think, at that point, really kind of having to look at redemption and having, putting the company in as the buyer to make up that gap. Certainly, it'd be a lot easier for the company probably to do it than an individual owner. So then you just kind of have to plan for that going forward.
Yeah. All right. Thank you.
This is Greg here. I just wanted to thank you guys. This is an excellent presentation. And Heather, I really liked how you tied in the importance of the team aspect and how, having the advisors all on the same page is so important. I think you guys did a great illustration of that just in your firm alone, and how communication between the shareholder agreement, operating agreement, and the estate plan of those individuals that you're working with is so important. In terms of answering your questions, Steve, on what's going on kind of in the field here. I mean, it seems like business owners are getting better valuations now than they've had in years. So I think there's an eagerness. Yeah, absolutely. I think there's eagerness to sell, and I'm sure that's probably picked up your practice and in preparing for those sales. And I don't think there's really any kind of I guess positioning towards one of the solutions compared to the others. I think there's still probably a little apprehension on some business owners on doing the ESOP because of the cost structure involved. But I like the fact that you guys had kind of brought somebody in and have that kind of a little bit more manageable, the cost of getting the ESOP set up. Because I think that's still a kind of a concern for some business owners. Selling to a third party is, I think, like we talked about with multiples improving, I think that's become very, very important. But many people still want to keep the businesses in their families, so it kind of varies. I don't think one is kind of the option of choice right now. But it's great to see for you guys and for everybody that activity has picked up in the M&A and the and business transition area. And this is great education. I just wanted to thank you guys for presenting to the group today.
Thanks.
I think business owners, entrepreneurs, spend so much time thinking about how they're going to start their business, and they really oftentimes fail to look at how am I going to exit the business down the road, which is just as important. You don't want to paint yourself into the corner. So this is,
Keith,
yeah.
I did have a question, if I could. I feel like we're trying to wind down, and I just wanted to throw this out,
please.
If that's okay.
Mm-hmm.
So kind of coming from a different perspective, as a trustee, if that corporation is going to stay in the trust, after the main owner has passed, do you have any recommendations on language to put in the trust that would assist the trustee if it is a corporate trustee that's going to be the trustee?
Heather, you want to take that?
Yeah, I can field that one. I mean, one of the things that we find to be incredibly important is being aware of the structure and allowance for ESBT or QSST, meaning that the trust can continue to function, and particularly if the business is an S Corp, right? We need to be very concerned about that. So that's kind of part one. We also, a lot of our clients we were talking a little bit about being more of a directed trustee, because often a corporate trustee, you're not experienced in running that business. So we will craft sometimes we call it sort of a special asset advisor or a business advisor, where someone apart from the trustee, apart from the corporate trustee, can advise and direct on operation of the business. And we find that to be a good strategy to implement the client's wishes. And then obviously just, authorizing the trustee to continue to maintain the business, even if it's, a large part of the trust assets. Those are all things that we find are to be important. But from the client perspective, and even from the trustee perspective, we've had a lot of success with that idea of the trustee is the trustee overall, but there's someone in place who can advise on issues specific to the management and ongoing continuity of the business. So does that kind of address the question, Ann?
Absolutely. Yes. Thank you so much.
Yeah.
Okay, I'm going to pause the recording here. Want to